Good evening, everybody.
Good evening.
Thank you. I like that. Does everybody know my name? Okay, for those that don't, my name is Stuart Schlossman, president and founder of MS Views and News. We created this organization now 6+ years ago, and we're looking to do it for another 60 years, hopefully long after I'm gone, because we're building up our staff and whatnot, that people, even after I eventually have to retire, will be able to take over this organization. You'll be meeting them in future years as they come up to run programs as well. Okay. Communication tool. Everybody have that on their table? It's called the Land of MS Communication Tool. You have it probably on your table. If you don't have it on table, then I'm sorry it wasn't given to you, but you should all have a copy of it. What is the reason for this tool? This is something, it's not a wrench, it's not a hammer, but we do call it a tool because it's something that you could use. Okay, this is to be used by you, so that way when you go to your next neurology appointment, whether you're seeing an MS neurologist or a nurse practitioner, everything that you have potential questions about concerning your disease state, there's a line item on here that you could click off and make sure you bring it with you. How do you get this? You can get it by visiting our website and getting it from there, or we're hoping that a lot of the neurology offices, even here in Jacksonville, will soon have these from us. Hopefully they'll give it to you before your next appointment. But if not, again, a lot of you make lists, but many times, even with that list that you bring to your appointment, you walk out and you say, oh my gosh, I forgot to ask you this. And the clinician says, well, I'm sorry, we don't have any more time. Well, again, if you fill this out in advance, start working on it a few weeks in advance of your appointment. Fill it out, bring it in, give it to the person at the desk when you arrive. Make sure they put it into your folder so that way when you speak, then get into the exam room and you're speaking with your clinician, again, whether it be a neurologist or a nurse practitioner, you'll be able to go through this entire checklist and hopefully have everything resolved before you leave your appointment. Okay, enough of that. I know you guys want to get started. I sure want to get started tonight as well. For tonight's program, we want to thank Genzyme, a Santa Fe company. I hope everybody appreciates that they gave us the funding to do tonight's program. Thank you. I'm sure they will thank you as well. Without taking much more of your time, tonight again, we have Lisa Gonzalez-Goetz. She's right here. She's going to come up and speak with you. 35 minutes she's going to speak with you. Then we're going to open up to Q&A. So come on up, Lisa. Let's get started. Thank you. You know your presenter, right?
Hi, good evening, everyone. My name is Lisa Gonzalez-Goetz. I'm an attorney based out of Fort Lauderdale, Florida. I practice Social Security disability exclusively for the last 23 years, and I'm very close to MS News and Views, and I follow them throughout and try to give education and help to anybody who's applying for Social Security disability, thinks about applying for Social Security disability, or doesn't even know what to do. They may have been diagnosed or in the process of application or denials. So I put together a slideshow. I'm going to go quickly through this because what I find more than anything is that there are a lot of questions. So we're going to pass through. I'm going to show you the overview of the program. That may help with yourselves or somebody that you may know that's applying and give you a little bit of an overview of what a case entails and what attorneys look for when they take a case of disability. Okay? So there are more than two, but basically two types of Social Security disability. There's a Title II program and there's a Title 16 program. Title II program is when you've worked and paid money into the system and then you aren't able to work, so you receive money based on the earnings of what you put in, your FICA taxes, and it's calculated by Social Security Administration. SSI is commonly referred to as Title 16 SSI, but people say SSID, and that's a little misnomer. So for Social Security, there are basically two types, the Title II and Title 16, and that's supplemental security income. Title 16 is for individuals who have not paid enough into the system to bring them above the poverty line. So if, as a rule of thumb, you have worked 5 out of 10 years, you have insured status, and you should qualify for Title II. If, however, you have worked but not 5 out of the last 10 years, or you have made very little money, which would not bring you above the poverty line, then you may be applying for Title 16, which is Supplemental Security Income, and that's based on having a finding of disability as well as a financial status. You have to have less than $2,000 total resources. There's some exclusions as a house and a car, but the house is as long as you live in it. So it's a very individualized factor. And Social Security handles a sole separate application process and interview process to see if you qualify for SSI benefits financially. So as I said before, disability is based on your inability to work, and the definition of Social Security is if you've not been able to work for 12 months or more because of a physical, mental, or a combination of impairments. So a lot of times we get diagnosed, but we continue to work. And that's very commendable, but you don't qualify for benefits until you've actually stopped working. There are some exceptions to trial work period, and there are different exceptions to how often you can try to work, and we're going to talk about that. But more than anything, if you are not able to work because of your physical impairment, or because of your mental capacity, or a combination of both, you would be entitled to qualify for Social Security disability benefits. The definition of work is 40 hours on a sustained gainful basis. So if you find that you're able to work but not work 40 hours consistently, you may qualify for disability. If you work less than 40 hours but you're making more than $1,800 a month, then that may be considered work. So every case is very individualized, and it can get very, very confusing, which is why I'm here. Many times people are explained this by Social Security, but they're not quite understanding, where do I fall into this? I'm making some money, I'm not working, I am diagnosed. How can you help me? What do I qualify for? So I'll be happy to answer those questions. So past relevant work, which you see here on the board, is work that you have done, and the past relevant time period is 15 years. So in the last 15 years, what kind of work did you do, and are you able to do that work, or are you able to do any other kind of work in the national economy that may transfer in? Those are vocational factors, and those factors get decided in court. And those factors get very often decided in front of a judge with a medical expert and a vocational expert. And that's where we come into play. We take cases at the initial level, so we'll apply for benefits for an individual. We'll do all the appeals, but most of the cases are actually won at a hearing level. And your disability has to be expected to last 1 year or result in death. So many times individuals will say, Social Security said I have to be out of work for 1 year before I can apply. That's not true. You have to be disabled and unable to work for 1 year. But our recommendation is for you to take advantage of that year. From the minute that you are not able to work, you file your application, and the application time takes at least 18 months, 12 to 18 months or more. So that gets eaten up in your year, as opposed to waiting a year of being unemployed with no income and then starting a process that's lengthy and time consuming. So this is my suggestion to anybody who's not working, who thinks they may be qualifying for disability or is thinking of applying, to do it sooner than later. And we'll go into that a little more because I have a lot of experience with that. Proper presentation, and the distinguishing factor between winning your case and not winning a case. So Social Security is a 5-step sequential process. The first one is whether or not you're working. The second one is whether or not the work is substantial gainful work activity, if you're disabled, if it's severe, how severe, whether you can work in a particular job, maybe not the work that you used to do, but any other work. So we go through that and we collect all of the medical records from your doctors. And we put a brief together for the judge, and that brief really encompasses your diagnosis as well as the information that your doctor says about you. Are you able to work? Are you, in fact, able to sit, stand, lift, carry, bend, squat? Do you have any environmental restrictions? Do you use anything to ambulate? And all of those things come together, and we try to put it together before we even go in front of a judge. And the reason is because we're trying to simplify the job for the judge. It's important for everybody to know here that you do not have to be an attorney to represent an individual before the Social Security Administration. The reason that you want an attorney is because if you do not win the case, then you need to appeal the cases. Most of the time, they're written briefs and they go into the Appeals Council in Virginia, and after that, you go into the federal court. So even though it's administrative and it's fairly laxed with the rules of evidence. So just as a showing of hands and to see who's listening to me, because I know you're all really waiting for the next speaker, how many people are currently on disability? Okay, and how many people, thank you for listening, by the way, and how many people are applying currently for disability? Okay, and so I saw 2 people that are applying, and that's normally what happens. Unfortunately, people come to these kind of informational dinners and gatherings a little late in the process. So for the 2 people that are applying, you're going to get a lot of very, very helpful information, not only from myself, but also from doctors and nurse practitioners talking about different kinds of therapeutic treatment and record keeping and complaints and documentation of that. And that helps us be able to do our case better. So this is what you see now on the screen is what an exhibit list looks like. Social Security disability is now electronic. So everything is online. We're paperless. And this is what a typical claimant looks like based on their exhibit list. So when you have an attorney, they go in, or a representative, I assume, they go in and you pull up your exhibit list and you can see real time what the judge has, what the Social Security Administration has on you, what you've ever said to them is documented. That's one of the main reasons that I think everybody should have representation at an earlier time. So when you apply for disability and they ask you questions, they may phone you, how are you doing, how do you feel, and you answer, oh, I'm good, because you're having a good day. They're going to write that down, and later on somebody can read that, and they can say, you know what, you're doing okay. You said you were doing okay on March 5th, 2014, but you won't remember. So it's very important to be very careful with what you say. It always gets documented, and it always stays preserved for your records. This, what you're seeing now, is an example of what your earnings record looks like. So every penny that you've ever made since the age of 14 or 15 gets documented and withheld by Social Security. As long as you paid FICA taxes, they have a breakdown of how many quarters of coverage you have. So in order to be insured for disability, for the Title II, you have to show that you have 10 out of the last 20 quarters, and this is an example of how you count the quarters going back. For people that may or may not know, if I worked 5 out of the last 10 years, maybe I worked 4.5. Do I have enough quarters? Why do they tell me I'm not covered? These are the kind of records that we read. Okay, so MS and several other impairments have also been deemed by Congress to be compassionately allowed. Has anybody heard that term before? Okay, so compassionate allowance is if you meet several criteria for these purposes, MS, and the criteria is of such severity that you would go to the front of the line and be awarded benefits before other people with other impairments. The theory behind it is that if you are very, very severe and your life is on the line, we should allow your case, grant you the benefits without the need of waiting for all this time. I'll answer questions. There's a double-edged sword that we'll talk about in the Q&A session about compassionate allowances. But just as a purpose of information, MS falls under that. Some other ones that do are certain types of malignant cancer, HIVs, MS with certain diagnostics, which we can go into. They're listed in the Social Security regulations and rules of impairments, so we can go through that also. But just so that you know, you can go in front of the line. For that, you need help with your doctor to complete certain forms to be able to get compassionate allowance. This is just a list of some of the allowances that come under compassionate allowance. It's not an exhaustive list. It's just some of the cases. And with MS, this is the kind of things that they're looking for. But they're very, very specific. And for this, you really do need your doctor to be completing and diagnosing and giving findings of facts and objective medical records to support it. Remind me of the double-edged sword afterwards in the Q&A session. Here's a little bit more about compassionate allowances, advanced malignant MS, and then aggressive Marsburg fulminant. So you can see here that it's not case specific. It's very specific in terms of the definition, but it's really based on an MD finding from your neurologist, from your general doctor, from radiologists, whoever has examined you and has the findings that you need for this. This is a process of the application, which takes between 12 to 18 months. Some cases get one very, very quickly. I actually believe that some cases, just based on saying that you have a certain attorney, Social Security will look at your case a little quicker. We can win a case in 2 weeks. We can win a case in 2 months, 2 years. My longest case has been 6 years. That's gone to the federal court twice and back. So the process is supposed to be very simple. You apply for benefits, you get denied. I think there's a chance of like 92 or 91% denial rate at the initial level. After that, you apply for reconsideration. You have 60 days. They give you 5 mailing days, even though now everything's electronic. So thankfully, you have the 5 extra days. And if that gets denied, and I think at reconsideration level, depending on the state that you're in, the numbers vary, mostly between 75 to 90% denials at reconsideration level. And then after that, you apply for a hearing. You file something that's called a request for hearing, and you're actually asking for an in-person hearing in front of an administrative law judge. And that's what I was showing you before. When you get ready to go before a judge, you put a theory of your case together, you get your medical records, you get all the treatment notes from your doctor, you put those together with your limitations and your impairments and the last date that you worked, and you try to go and win the case for as far back as you can. There are certain listings of impairments. In theory, if you qualify for any of these listings of impairment, disorganization of motor function, visual impairment, organic mental disorder, then there's several other listings. These are just a non-complete list. If you qualify for these, you should be automatically given your benefits. But most of the time, you need most of the time they just deny you and say you don't qualify, and that's it. So we try to get as much as we can from your medical doctors to support a listing criteria. Those are very case specific, and there's certain forms for that, but anybody can look these listings up, and they talk about very specific limitations with visual impairment, accuracy, perception, depth. When it comes to visual, organic, it comes with MRIs and findings, and motor function. Do you have ambulation? Do you have positive MRIs? It has to be well documented. So that's me. I'm a graduate from University of Florida. I went to Temple Law School. I practiced with my husband, David Goetz, and we practice nationwide. This is the only kind of law that we do. So I would suggest to anybody who's looking for any kind of help with Social Security, please ask the person who's giving you the information whether or not they do other kinds of law or if they're specific to only Social Security disability. And the reason is it's a very case-specific type of practice with a lot of changes. Right now we are in an election year. Things are slower, denials are higher. So you want somebody who knows the ins and outs of the program and is able to take your case from the beginning all the way and exhausts all appellate remedies. I hope I can talk for a long, long time, but it's been my experience that a lot of people have questions. Either if you are on payment status, have questions as to whether or not my benefits are at risk, or if you have any questions regarding your own benefits right now or your own application. So there's a lady in the back. I'm going to open to questions.
Two questions. One is, I did get Social Security, but I got it after 3 years of being denied. So then I got it in a lump sum. Then I had to pay taxes on all that because I got a lump sum of 3 years. If they would have gave it to me as they should have, back to day one, I wouldn't have had to pay all those taxes. That was the first. And then why is disability only till age 65?
Why is disability what?
Only till age 65.
Okay, so the first question is you have a lump sum amount of money, and it's because your case takes so long. So let me explain that for anybody that may not know. When you stop working and you apply for disability, from the date you last worked, depending on what program you're applying for, the monies that you're entitled to get banked. So from the time that you stopped working all the way through to the time that you win your case, that money gets accrued and then you get paid. Okay? So as a sidebar to that is people often ask, how do attorneys get paid? And attorneys get paid based on the retroactive fee. Every attorney has to be statutorily approved, and every attorney is capped at $6,000. So whether you take the case for a month, a year, 2 years, 3 years in your case, you are capped, okay? There are exceptions, and I have to tell you, I just looked this up this week. The money that you receive from Social Security is taxable only if, and I don't remember exactly, but I do know that it's only if your gross household income exceeds a certain number. And then, meaning you have a spouse that's also bringing in income, and then it's taxed up to 15%, I think. So there's a whole calculation, and I'll be happy to send you anybody who wants an email on that. But there is a whole calculation that the government does. So it's not often that it gets taxed, but you are seeing it in double home incomes more and more often. So that was the first question. And the second question?
Why is SSD only to age 65?
Okay, so this is a term that I said before. You're going to hear SSD, and I never really know what people mean by SSD because there's Title II and Title 16. So it's either DIB or SSI. So if you're Title II, okay, so it's the same program, it's just facilitated through a different department in the government. So if you're on retirement benefits because of an early disability, you fall under one program, and then they switch you on to another program. But money-wise, it should not make a difference. And it entitles you to Medicare. So money-wise, it shouldn't make a difference. You can be 68 and still be receiving the same thing you were receiving at 64. It doesn't end at 65. It's just managed by another part of the government. Okay?
Hi. I would like to go back to work part-time at something like minimum wage. And I'm trying to make sure that I don't put my income at risk, my Social Security income at risk. I believe what I've got is Title II, under
Yes,
Title II.
yes.
So that's my question.
Okay.
Are there general guidelines that I should follow, and what do I have to sort of be on the lookout for?
Okay, so anybody who's receiving benefits is entitled to getting a review, okay, at any time within 2 to 5 years, sometimes 7 years. Somebody from Social Security will contact you and ask you, are you still getting treatment? Have you improved? Are you better? And you normally complete the information and send it back, and that's the end of it. When you do any kind of work, once you start reporting income, even minimum wage, you are alerting the government that you're feeling better, and you are red flagging your case for a review. Now, Social Security has income limits. So they have a couple different ways of looking at a case. You can go back to work for a period of time, and that's called a 9-month trial work period. In that case, it doesn't matter how much you earn. It's just questions as to whether or not you have 9 months where you tried to work. If you fall in that category, you have 9 free months, it doesn't matter, but that's a lifetime. So it's not just for this period of time, or per calendar year. It's 9 months per lifetime. The other way that people work and get disability benefits is by working and earning, I think right now the figures were a little under $1,800 a month. That's a very high amount. That's a very high amount. You know, my thought on it, and it's a very personal thought, is if you feel stable enough and you feel like you're able to work, give it a try. But don't work and put yourself in a situation where if your benefits are at risk, it can take away what's making you feel so well. So it takes a long, long time to get benefits. It's a very hard, humiliating, difficult process. Absolutely very difficult process. And it's only getting harder right now. So every time somebody goes back to work, you're flagging yourself and you're opening the door to go through this again. My suggestion has always been start with a volunteer, work a few hours a week, 5, 7, see how you're doing, and talk to your doctor and see how that goes.
Sorry, a follow-up. You mentioned $1,800. Is that a high amount, but would that be factoring in the income that I already receive? In other words, what I get already from Social Security, then I have to add to that, and once I get over $1,800, that's when I'm red flagging?
No, any time, and I want to make this really clear because this is a question I often get. Any time you're receiving benefits, you're open for review. Anytime you pay FICA taxes and you're showing that you're working, the question becomes, are you working, and how much are you working? And are you keeping the hours artificially low so that you can double dip? And are your income numbers enough to bring you over? So anything is suspect. even if you bring in earnings in excess of $500 a month. And we are talking earnings. We are not talking what you receive from disability. We are speaking, you finally got benefits, you finally have your health care, you're finally feeling better, and you go back to work. That will open the door for review. You're welcome.
I was wondering, once you have an attorney, if you've been denied, like say 3 going on 4 times, and you're at your almost final appeal, can you switch attorneys?
Yes, you always have a right to switch attorneys. An attorney can't touch your case. So, for example, if you wanted to ask me a question about your case afterwards, I wouldn't be able to give you any kind of advice because you currently have an attorney. But people do switch all the time, and of interest is, just as a side note, we have people that come to us, then they jump to another attorney, they come back to us. They think somehow the attorney can speed up the process, and the cases just take a very long time. You can switch attorneys at any time, and if your attorney, and that's I mean, if you go to a neurologist, you're going because you don't have a toothache. You're going for neurological problems and gait problems and motor function problems. So you wouldn't go to an attorney that does anything else but Social Security disability law if you're going to be applying for disability. You can switch at any time. You probably don't have 4 appeals. If you had 4 appeals, you would be at the initial, the reconsideration, request for hearing, and at the Appeals Council in Virginia. After that, if you're at the Appeals Council in Virginia, you're waiting a while. Those cases can take even up to 2 years. And then after that, if you get denied again, it's federal district court. Or file a new application and start again. Age plays a big factor in it. Work plays a big factor. The judge that hears your case plays a huge factor, and your vocational issues also play.
Yeah, I had a very difficult time with my credibility. Things such as stating I have a difficult time showering on a daily basis. But because it said I was well groomed when I went to the doctor. Things such as stating, I have depression, but it's stated in my doctor's notes that I was cheerful that day.
Right.
It was just the ridiculousness of the denial due to my lack of credibility for things that I felt were absolutely ridiculous.
So you have a great point there, and this is what I deal with every day. First of all, remember, every time you go to your doctor, remember to only complain, because these records are being reviewed. So that's kind of like a diary, and it's very, very helpful. Anytime that anything is helping you, you want to just tell them, but don't have them really documented, because that's exactly what happens. The sole job of an administrative law judge, which is where most of the cases are heard, is to assess credibility, okay? And that is the hardest part between appealing a case, because that is their sole function. So on the one hand, you can say you didn't follow the law, these are the listings, these are the medical records, this is what the doctor says, these are the limitations, these are the vocational factors, these are the repetitivenesses, and you go into, you go and you break the case down. But having a hearing in front of a judge, that's where the judge can say, I have seen and observed you, and I believe that you were exaggerating. And the only way to win a case on appeal is to have those good medical records showing I'm not exaggerating, because you're seeing me one day in a progress of 2 or 3 years of applying, but my doctor is my treating physician, the treating physician rule should follow, and my doctor has seen me consistently every 4 weeks, every 6 weeks, and has documented it. So those are very, 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 very challenging issues. And those are very big, hefty briefs that you write, 6, 7 page briefs breaking down your medical records and finding every single line that you say that you're not able to work or you are having these problems.
So is it better at this point to go ahead and start over with a new date?
Okay.
Or to go ahead and try to fight it?
Okay, so that's a great question, but like I said before, because you have an attorney, I'm not able to give you any advice. You have to actually speak to your attorney, and like your relationship with your doctor, it has to be one of full confidence, and you have to trust them. And if they're not giving you that trust, that's a different story. You can always switch. But the truth is that you have to know that they are backing you up. And an attorney for Social Security doesn't get one dime for all that work unless they win the case. So as long as they're a reputable attorney, if they're taking your case, it should be because they believe they're going to win it. And it's not a numbers game.
I have a question specific to types of jobs, like working as an independent contractor. Does Social Security look at that differently? For example, I'm a licensed realtor. If I wanted to go back and activate my license, I'm paid once a year at the end of the year with a 1099, so I don't pay FICA until the end of the year. How is that looked on?
It's looked at.
Oh, I'm sure it's looked at. But
it's looked at. So I'll give you an example. I had a person who was an independent contractor. They were in real estate, okay? And it was when real estate market was better. And he would make a phone call. He didn't have to show. He didn't have to do anything. And he earned, because of a referral or the way it was, income. That was considered work, and there was nothing he could do. Same thing with a stockbroker. Somebody that, based on a phone call that he did, was able to sell some stocks and receive some income. That was income. So the questions are always not only the amount of income, but what kind of work do you do to get it? They will look at it. If you need licensing and you're over 55, over age 54, 55, you may fall under these grids, which are Social Security designated grids that everybody uses to show whether or not there's any work that you could do in the past. But rule of thumb is the more skilled your work was, the more jobs they'll find for you.
I had a question going back to work. There's something called Ticket to Work that you have to reapply for before you even start the process, right?
It depends, I think, on the state, because I've heard of Ticket to Work, and many different states, we go nationwide, they all have their own type of sometimes it's for work, sometimes it's for schooling. And again, when a person is not able to work, okay, they apply for disability. If they try to work and they're not capable of continuing, it could help your case because it could show that you want to work but you're not capable. But if you try to work and you're able to, then you don't qualify for disability. In order to get several different types of assistance from the states, they're requiring now more and more that you apply for these programs. And in that case, you have to. And we go with a case-by-case basis. I'm going to give you an example of a federal issue that happens with. So, for example, how many people in this room have ever applied for unemployment? Okay, so when you apply for unemployment, you are signing a statement that says you are willing and able to work. That same statement by some judges will say you were willing and you were able to work. So if you signed that just to get a check, you were committing fraud. But Social Security regulations have said that in and of itself doesn't mean you don't qualify for disability. So it always is subject for interpretation. So I guess as an attorney, I'm very long-winded and I can keep going on and on and on. The bottom line is you do what you have to do, but it always may come with consequences and you have to work around them. Okay?
Why is the rejection rate so high? You say 90% plus in a lot of these. And is it because the government's trying to save money out of this fund? I've been told that the disability part is declining even faster than the total Social Security benefit program in terms of number of years of coverage. Do you have any insight on that?
I can give you my personal opinion. I don't have any insight other than, well, let me give you my personal opinion, then let me tell you what some judges say, and then let me tell you what I think is the law of attrition plays statistically in applications. So when you apply and you get denied, and you appeal and you get denied, statistically, they have observed how few people pursue and how few people pursue. So they're very quick to deny, and a lot of people in the last 4 or 5 years have returned to work. Some people who are very, very sick and have no business working, but they are working because they were denied. Okay, so I think it's a play on numbers, and it does save the government money. I think there's also a lot of fraud. About 2 years ago, maybe a little bit, 2.5 years ago, 60 Minutes ran a report on the fraud in Social Security, and they were doing it specifically with one office and a set of judges, and it went nationwide, and it went ballistic, and the judges were very reactive. And the administration was very reactive. So, as our administration does, they react very strongly when something happens and public opinion changes, right? So the administration decided we are going to put the kibosh, and we are going to, instead of hiring judges from the outside and train them to be judges, we're going to hire them within the administration. And in the last 10 years, and more so in the last 4 years, and even more so in the last 2 years, the judges that you have used to be staff attorneys and have worked up the ranks from inside the federal government. And they have been persuaded to not grant as many benefits. They have been demanded to increase production. So you will have a hearing now in front of a judge, and in order to increase production, we have hearings that are handled, which is why we can do it nationwide, on TV. The National Hearings Office in Baltimore has hearings, in Naples, here, everywhere. These judges are traveling, and the judges are writing your decision as you're presenting your case. So you have a client in front of you, and the judge is standing here, sitting here, and he's with his monitor here, and as you're speaking, he's writing a decision, and he's not even looking at you. And really, I think it has to do with production. They want you to pop these decisions out. They have cut staff in Social Security, so they have less help with writing. But it's really deplorable because you wait this long to have a hearing. You have, I had in the month of August, 5 people die on me. Okay, so it's a real serious problem, and what attorneys such as myself are doing, some older practitioners are actually retiring early because they can't handle it. And what we're doing is we're bottlenecking the federal court, the appeals council, the federal courts, so that then they can come back and tell the judges, this is what you're doing wrong, this is what you need to do. But I don't have any other answers other than my own perspective.
Question over here.
Hi. I was just going to reiterate what you were saying about having a paper trail, because they love to see, and complain, everything, even if you feel great and sublime that day, everything that happened, you could be on the floor flat, and you couldn't, with an exacerbation or something, let's say an MS, you tell the doctor. When the doctor says, how are you doing today, Mrs. Smith? I'm fine. We all want to do, no, I fell on the floor, my kids weren't even at home, you know. I had to crawl to the door, whatever. I'm not saying for anyone to exaggerate, but just tell the truth about everything. Because if you don't have a paper trail and it depend on the Social Security appointed doctors and physicians and clinicians, that's one little tiny myopic view of you that day. And maybe you had a pretty swell day, like you said, and they're trying to bend you all over and you're fine, and then the next day you're flat out. And they don't care. That's their report.
My advice has always been, when you talk to your doctor, talk to them about your bad day. And another thing that works really well, which will help with your doctor, is either following what MS News and Views has in terms of keeping track of all your questions and your complaints and your symptomatology. That is evidence. Or even diaries. People keep journals, like the books that were given to you today. If you keep a journal and you keep documented, it could be, as long as it's regular. So it could be, if it's every day, every week, every month, but as long as it's regular, it could be submitted as evidence. And that carries a lot of weight in issues such as credibility. Huge weight, so you're right.
Hi.
Hi.
I have a question about I'm on disability currently, so I just wanted to ask, the monthly payment that I receive is because of a calculation of what I made the past whatever years. Is that right?
That's correct.
That's right. Okay.
That's correct.
Okay.
And it's very individualized. Yes.
Any other questions? No other questions? You have another question? No. Any other questions?
You can ask me later if you want.
Yes, Lisa
Okay,
will be around
great.
till the end of the program, so if anybody has any questions for her afterwards, please feel free to come see her. Otherwise, let's give her a round of applause. Thank you.